BlomCast. Turning Points in History. Wendepunkte in der Geschichte. Good evening, and thank you for being here, and thank you for sharing this moment with us. Thank you for engaging on an evening of big questions and not so big stories. On an evening that has as its title the subtitle of this book, namely Impunity, Straflosigkeit. And we will talk about this book, we will talk about international law, we will talk about motivations, we will no doubt talk about Myanmar and about Gaza. But before we engage in these rather theoretical questions, it's always good to know where someone comes from. And when we ask what motivates us, for instance, what motivates criminal actions, what motivates us to work, what motivates us to write books or to become a lawyer. Misha, tell me about the attempt to find your grandfather's house, and tell me about the questions you didn't ask your grandfather. Philippe, I'm sorry. I was looking at Misha there in the background.
I think we should invite Misha.
Philippe, let's make sure that the right grandfather is described here. Philippe Sands, yours.
First off, it's incredibly nice to be here. I'm incredibly grateful to MQ Gespräche and to the Kreisky Forum, with whom I've got a long relationship, and also to Misha and the IWM, where I go back some time. And Misha is very mischievous, and my wife would be incredibly irritated by that introduction, as he knows, which is probably why he did it. But your question, and Philip and I actually had dinner last night, a wonderful dinner with Veronica, his partner, but we agreed I did not want to know which way he was going to go in this conversation, because it's much better to be spontaneous. It's a genuine conversation. And actually, your very first question is the beating heart, in the sense of so much of what I do. We are in Vienna. My roots, in many sense, are in Vienna. My mother was born here in July 1938. It's a city that is very complex for me. I only came for the first time in 1988 when an NGO called Greenpeace brought me onto their delegation to help negotiate the post-Chernobyl legal treaties. And Vienna and Austria was just a place that was basically forgotten. No one wanted to talk about it. And over the intervening 35 plus years, my relationship has changed very much. In a sense, the reason that I'm here is catalyzed by the writing of various books, including Rückkehr nach Lemberg, East-West Street. And that is essentially about a question of identity. When I was invited to give this lecture on the cases that I do on crimes against humanity and genocide, I get an invitation from a place I've never heard of, the University of Lviv. Then I learn that Lviv is Lvov and Lvov and Lemberg, and it's all the same place. And I go to the university not because I've got a burning desire to give a lecture, but because I want to find the house where my beloved grandfather was born, Leon Buchholz, who fled Lemberg in 1914 when the Russians occupied. History goes round and round, and came to Vienna and made a life for himself in Vienna, married, had a child, my mum, and then fled in January 1939. So the beating heart of these books, and really much of what I do in my engagement with accountability and with justice, is to do with Vienna, frankly, very frankly. And I have to say, this is a very special day, because my relationship to Austria changed yesterday in a very unexpected way. I'm sitting here, since we're talking about international law being dead, as an arbitrator, sitting on a dispute governed by international law between an Austrian investor and a Central European country involving an allegation of expropriation. And I can tell you, the 40 plus participants in that room do not think international law is dead. And I'm sitting there with my co-arbitrators resolving a dispute under international law. So some of it may be dead, but certainly not all of it is dead. And so I left the hotel, which was on Schottenring, where we're doing the arbitration, and I headed to Philip's apartment on Skoda Gasse. And of course, I wondered, is that the same Skoda as the car? But halfway
It is
there,
not, it was a pathologist.
but halfway there, I came into a square by the National Bank and was totally astonished by what I saw. I had not known there was this monument with every single name attemptedly put on. And I got there a little late because I, of course, was distracted. And I went and found all of the names of my great-grandparents. And it was incredibly affecting, I have to say. But it was also very important in another way, because I've always, to speak very frankly and with the greatest respect, particularly for my friends in the audience, had a problem in Austria. I've never felt very comfortable. And part of the reason that I've never felt very comfortable, as I do in Germany, very comfortable, is about engagement with the past. And here I was confronted with an expression of engagement with the past, which was intimate, which was individual, and which was different. And I said to my wife this morning, something very important changed yesterday. Seeing that thing right in the heart of Vienna instantly transformed my engagement with this country. It's really strange and interesting that has happened, but it's a very important question that you ask. And in a sense, this is day one. I mean, I've always had a good relationship with Austria, but now this seems different. So your question is a very important one.
To ask the question partly again, what were the questions that you didn't ask your grandfather? Because he didn't only make his life in Vienna, but you met him. He is your personal connection to this bigger story.
I'm often asked, what regrets do I have in life? And I always focus on a single thing. I never asked my grandfather, what was your mother like? And the reason that I didn't ask that question is that as children, my brother and I knew that something terrible had happened, but we were never allowed to talk about it. And so we self-censored. And I, lived on this planet for 38 years with my grandfather. I knew him very, very well. And I never asked him, what was your mother like? Because we knew it was such a painful question for him. And yesterday, being at that monument, seeing his mother's name engraved on that wall, Malka Buchholz, 1870, I really immediately just thought of him and how would he have reacted. And I think he was a man of, he was impecunious, but huge amounts of dignity. And he would have wept and he would have said, that is a good thing. That's what he would have said. So, I mean, we've all have regrets. I've homed in on a very single and very intimate one, but in a sense, connecting to these bigger questions. Why do I care about truth and memory and justice and identity? And why did I study international law? Very simply because when I went to university and changed from economics to law, we'd had a great economics teacher at school, and called Edmund Burke, incidentally, from Yorkshire. And I switched to law, which I hated, except for one course, international law, taught by a Yorkshireman called Robbie Jennings, who was wonderful. And all of a sudden I was studying something in boring law school that connected to my own family situation. And I was captivated by it. And my grandfather came for my graduation. For my LLM in particular was very important because my teacher in the LLM was someone else who had roots in Vienna, Eli Lauterpacht, the son of Hirsch Lauterpacht, one of the most famous international writers of the 20th century, who did his doctorate here in Vienna with Hans Kelsen, and then left, not under difficult circumstances, but because he wanted to go and live in England for some reason. And extraordinarily, my grandfather Leon met Ellie Lauterpacht and Ellie Lauterpacht's mother, Rachel, at my graduation in the party afterwards in the garden on Cranmer Road in Cambridge. And at that point, it was June 1983, we did not know that the origins of our two families, the Lauterpachts and the Buchholzers, Flaschners, was on the same street in this town called Żółkiew, east of Lemberg, 20 kilometers east of Lemberg, Lembergerstrasse, West Street, as Joseph Hott would have called it. And I find these points of connection and coincidence remarkable. And so there is, in so much of what I do, a sort of Austrian element, a Viennese element. And I'm proud of that. I celebrate that. Something I'm comfortable with.
What you've just described is also very much of an image of this book that you've written, 38 Londes Street, which is a whole series of connection points that are connected by historical coincidence, by historical structure, but also by your passion as an investigator to get these things together. And they knit together a part of the Holocaust with the regime of Pinochet, with your own role in the story of the famous Pinochet case, the arrest of General Pinochet, and then eventually the quiet release back to Chile of him. Tell us briefly. Tell us about your role in this. What connects these dots, and what makes this book? What makes the heart of this book beat?
So in October 1998, as many of you may recall or would know, Augusto Pinochet, the former dictator of Chile, was arrested in a London hospital room where he was recuperating from an operation on his back and charged with genocide and crimes against humanity to be extradited to Spain. And 2 weeks later, I was contacted by his lawyers and asked to act for him, to argue that he had absolute immunity from the jurisdiction of the English courts because the conduct was that of, while he was head of state, it was official conduct and he had immunity. And to be honest, I would have done it, possibly not with a great deal of enthusiasm, but because in England as barristers, I'm a barrister, we have something called the cab rank principle, the taxi driver principle. Someone hails us and we're not allowed to say, I don't like that person, I don't like their politics, I don't like the cut of their jib, etc., etc. We have a responsibility to take the case. There are exceptions. But when I told my wife, because we were actually coincidentally in Paris at my grandfather's funeral, that this call had come in from my chambers in London, she said, well, will you do it? And I sort of mumbled about the cab rank principle. And she said, well, I know, but as you know, Philippe, I'm American. This is her speaking. And the cab rank principle is bullshit and I'm not going to do it. So will you do it? And I said, well, cab rank principle. She said, well, okay, you can do it if you want to do it. But if you do it, I will divorce you tomorrow. So I didn't do it. Incidentally, when I tell this story in Chile or Argentina or Spain, everybody claps. In England and in Austria and the northern countries, they are less. So I said no in the end. And 3 days later, Human Rights Watch came along and said, would you act against Pinochet, that he has no immunity? And I went crawling to Natalia and she said, yeah, thumbs up, you can do that. So I did it. And so I was in the room. I mean, we were just interveners, so it was a modest role, but it meant that we were in the room and we saw absolutely everything. That was 98. Nearly 20 years pass, and then I'm off on this sort of, crazy journey from Lviv and Hans Frank and Lauterpacht and Lemkin and my grandfather.
Remind us who Hans Frank was.
Adolf Hitler's personal lawyer from 1928 to 1933, then Governor General of Nazi-occupied Poland, and tried at Nuremberg and sentenced to death for the murder of 4 million human beings. It's very hard to get that around one's head. In writing the book, possibly because I'm a litigator, this is a response to what Misha said, why do I go in this way? We leave no stone unturned, because the question you're most worried about is the question from a judge, which indicates you haven't really established the facts. So one of the facts I wanted was about Hans Frank, and I came to know his son, Nicholas Frank, who is a remarkable person, who has become a very dear friend. And one day Nicholas said, would you like to meet the son of my father's deputy, Otto Wächter, Viennese? Name will be known to very many of you. I said, sure, but I don't see why he would want to meet me. But anyway, we did meet, and I was introduced to Horst Wächter, who lives a little north of here, in the small village of Hagenberg. And I'm very pleased that in the audience today is Horst's wonderful daughter, Frederica, with whom I've become very close. And while I was getting to know Horst, who was very generous in sharing materials, I suspect he now thinks too generous, because he gave me access to the 10,000 pages of family archives, letters, postcards, and so on and so forth, an extraordinary trove, which I used to write Die Rattenlinie, which is the story of Otto and Charlotte Wächter. He, of course, ends up in Rome, where he passes away in mysterious circumstances. That's the subject of the book. But amongst the 10,000 pages, I find a letter, 3 pages, typewritten, sent from Damascus, May 1949, to Rome, to Otto Wächter, who's going under the false name of Reinhard. And the letter basically tells Wächter, don't come to Syria. It's not a good place for us Germans and Austrians. Head to South America. Wächter never gets there because he dies. But the writer of the letter I become interested in. His name is Walter Rauff, and I Google him and learn that he is the man who managed and operated the system of mobile gas vans that would drive around Central and Eastern Europe, managed out of Berlin, where he worked in the same office under Heydrich and Himmler and with Adolf Eichmann, and gas groups of people in it, of about 50 in these little vans. And after the war, he was hunted and he escaped and fled to Syria. So I got interested in this Rauff fellow and followed up and followed his path, which was to then himself follow his own advice, head to South America, set up shop in 1950 in Quito, Ecuador, where they make a new life for themselves, Mr. and Mrs. Rauff and their 2 boys, Walter Jr. and Alf. And in 1956, they meet, as I will learn, a delightful Chilean couple who say, you're in the wrong country. You should be in Chile. We like people like you, and there are plenty of lovely Germans in Chile. I know, it is filmic. And so the Rauffs set off for Chile, and they eventually settle in 1958 in Punta Arenas, the southernmost town in the whole world. Just out of curiosity, has anyone here been to Punta Arenas? It's an amazing place. It's an amazing place. And he becomes the manager of a king crab cannery. You couldn't invent it. And I've met many of the ladies who worked on his production line and learnt a lot about him. And then in 1963, disaster strikes because the West German prosecution service tracks him down and tries to extradite him from Chile to West Germany to be tried for genocide and crimes against humanity for the gas vans. But he's not extradited because the Chilean Supreme Court rules in its wisdom that there is a statute of limitations of 15 years. In Chile, and so he cannot be extradited for crimes that occurred 21 years earlier. So he goes back to Punta Arenas, and from that adversity makes his life. And on September the 11th, a moment of utter elation and triumph, when the coup d'etat occurs in Chile, Allende is overthrown, and a 4-man military dictatorship takes over the country and installs an absolutely brutal regime. Rauff is thrilled because the head of the 4-man military junta is none other than the husband of the delightful couple, Lucia and Augusto Pinochet, who they met in Quito in 1956 and encouraged them to move to Chile. And so the moment I discovered that, I asked myself the question, could it be that Walter Rauff was somehow involved in the disappearance of human beings after September the 11th, 1973, disappearances that landed on my desk as a barrister in 1998? Because if there was a connection, that would mean there was effectively an unbroken line from Frank and East-West Street story through the Wächter story in Die Harte Linie, through to 1973, through to 1998 in London, and that would be an extraordinary thing. So that is what this book is about. Was there a connection?
There was a connection. It leads us deep into the dark heart of the Chilean dictatorship. This house, 38 Londes Street, turns out to be a very interesting and very terrible place because it's a famous, it's a classic upstairs, downstairs story, what's happening. This is upstairs, it's a literary salon, downstairs, something else.
That's the Via Naranja. It's not 38 Londres.
That's right.
Yes. The 38 Londres is a building right in the center of town. It was the headquarters of the Socialist Party until September the 11th, 1973. It was then appropriated by the Pinochet regime, personally by Pinochet, who signed the order taking it over, and turned into a detention center, and then an interrogation center, and then a torture center, and then a place from which people were disappeared forever. And the reason the book has this title is that in July 1974, a young man called Leon Gomez was arrested, taken off the streets as a leftist, anti-Pinochet type of person, and taken with 6 others to 38 Londres, Calle Londres 38, 38 Londres Street, and interrogated and tortured. Out of the group of 7, the other 6 disappeared and were never seen again. And they continue to be disappeared today, and it continues to be a really big issue in Chile. But Leon Gomez survived and told me the story of what had happened. And while he was being interrogated with a blindfold, he heard a German accent. And he managed to peek through the bottom of the blindfold and see an older man in a very elegant suit sitting behind a little table with a typewriter, who was barking orders to the people who were applying the electricity and other techniques of interrogation and torture. And he recognized Walter Rauff. And the reason that he recognized Walter Rauff was that 10 years earlier, when Rauff had gone through the extradition proceedings, his photograph was on the front page of every newspaper in Chile. And Leon Gomez, as a 10-year-old boy, loved history and would ask questions to his father about who was this man. And that was how I got the first point of connection between Rauff and Pinochet. And the rest of that part of the book is a sort of digging away to find more and more connections. I will find other victims, if you like, who are on the receiving end of Rauff's generosities. But then I go to the other side and I meet former intelligence agents, the DINA, the Dirección de Inteligencia Nacional, people who were the torturers and the killers. And they have encountered Walter Rauff. And so I'm able to join all of the dots together. And I'll keep the main big reveal off because it is so shocking as to be almost unbelievable. I'll simply say that in writing this book, there are a lot of literary connections that were very unexpected for me. There's a great English writer called Bruce Chatwin who wrote a book that was, for our generation, a cult book called In Patagonia, which we all, I read it at university because we all imagined going off on the trail of Chatwin to South America. And unbelievably, Rauff features in Patagonia. Chapter 96, there is a man in Punta Arenas who dreams of pine forests and sings German Lieder. It's an amazingly glacial, very short paragraph, extraordinary paragraph. Ralph features almost unbelievably in a novel published in 1997 by the great Chilean writer Roberto Bolaño, Nights in Chile, where Bolaño, as a novelist, posits the idea that there could be a connection between Pinochet and Ralph. And Ralph has a role as the character who is looking for a teacher to give to Augusto Pinochet lessons on the writings of Gramsci and Marxist theory. You couldn't invent it. I just love the idea that a novelist is already ahead of the game. But almost remarkably, there is an opinion piece written by the great Chilean poet Pablo Neruda in 1965. He's incandescent with the Chilean courts for having let Ralph off the hook. And so he writes a vitriolic op-ed piece castigating the system of justice in Chile and the Chilean judges for not doing justice and not sending Ralph to West Germany. And then he writes, the one thing we can say for certain about this man Ralph is that he knows all there is to know about vans. Now, that's written in 1965. And as you know, Philip, given what I will later discover about Ralph's role in the disappearance of thousands of people in Chile, that is an extraordinary, prescient line by a poet.
Let's return to the idea of impunity. Ralph got away with it, and he got away with it in the courts. Pinochet didn't quite get away with it. His life was a changed life afterwards, after this trial. But more importantly, it established a precedent, something that was really new in international law. Impunity for heads of state, impunity for powerful people. Somewhere in the world was something else afterwards than it had been before.
So Ralph did, in formal terms, get away with it. No question. I mean, there was an effort to extradite him that failed. But in another sense, he didn't, because he never really recovered from that effort to extradite him. Not a day passed where he did not worry about meeting the fate of Eichmann, for example, and being abducted and taken to Israel or some other place to be tried. And we see that in his letters, his correspondence, the stories that he told to people. So, for example, every single time he left the house, he would leave a note on the table saying, I'm leaving at 3:25. This is exactly where I'm going. I will be back precisely at this time. If I'm not back, call the police. And he always went out with his dog, Bobby, an absolutely vicious Alsatian. And I can tell you it's a vicious Alsatian because I've seen video of that actual Bobby dog. And so he lived constantly with this fear, and that, in a sense, means it's not a total impunity. Pinochet's story is much more complex, and my friends in Chile are very divided. He gets arrested, and this is an absolutely historic moment. Never before in the whole of human history, ever, has a former head of state of one country been arrested in the territory of another country on the basis that they are alleged to have committed crimes under international law, genocide, crimes against humanity, torture. It's the first time it's ever happened. And so when I was asked by Zainab Badawi on the BBC World Service a few days later, does he have immunity? I just said, I have no idea. We don't know. This has never happened before. We're in totally uncharted waters. We know that if he was before an international tribunal, Nuremberg, Yugoslavia, Rwanda, he wouldn't have immunity. But this is different because it's a national court. And so what the English courts had to decide for the first time ever was, does he have immunity for international crimes? And the answer famously came down, no. And that was indeed the first time. Now, we know in the end he was not extradited to Spain. The Home Secretary, Jack Straw, decided he was not fit to stand trial. He was demented. He was too old. And so he was sent back to Chile. And that upset a lot of people and made other people very happy. And at the time, I remember it very well, those of us who were involved in the case sort of smelt a rat. I don't know how you translate that into German, but you know what I mean. There was something dodgy about what had happened, but no one could ever find out what had happened. So the second detective story in 38 Londres is what really happened. And I've got absolutely to the bottom of that. There was a deal between Chile and the United Kingdom, and I've met all the negotiators, and I know all the terms of the deal. And the issue of impunity is absolutely at the heart of it. Because when Pinochet returned, he was stripped of his immunity in Chile, and he was indicted serially. And at the time of his death, 5 years later in 2006, he was under house arrest and could not walk on the streets of his own country. So again, that is not total impunity, but a lot of people are very upset that he never was tried and that he was never convicted and sentenced. So it's a sort of halfway house. But more to the point, just two factors to think about. Firstly, until March 2000, when Pinochet returned, there had been not a single case in Chile, in its criminal courts, addressing the crimes of the dictatorship. There was a blanket amnesty law, and there was total immunity for all the top people. Not a single person had been tried or convicted for the crimes of the regime committed on the territory of Chile. And that all changed when he returned. And the gates of justice opened, and hundreds of people were tried, and many people are now in prison serving life sentences because Pinochet was arrested in London. So you can't say it's a case of total impunity. But there's a bigger issue that's at the heart, for me, of the whole thing, and which is a theme in the book. Just as in East-West Street, I oscillate between Lauter Pact and Lemkin, and am I for the protection of the individual, crimes against humanity, or protection of the group, genocide? And I don't express a view in that book. And I've got a similar tension in 38 Londres. Should he have gone to Spain? Should he have gone back to Chile to be tried? And again, I leave it to readers who are smart to form their own view. And reasonable people can have different views in the answer to that question. But there was a very big issue for a lot of people, and it was this. Although Spain plainly had a legal right to exercise jurisdiction through the work of Baltasar Garzón and Carlos Castrosana and Juan Garcés, the three main Spanish lawyers, what was the moral right of Spain to exercise criminal jurisdiction over a man who had committed crimes on the territory of Chile, when Spain has never tried a single person for the crimes of the Franco regime? Not a single person has been tried for that. That raises, I think, a very big moral issue.
This is a great segue to where I would like to go in this conversation, because we are getting closer and closer to today and to the question of impunity today and what that means, but we are also getting more and more close to the question of double standards, and that we seem to have our favorite crimes against humanity that we are terribly upset about, while others are not much talked about, not so exciting, and our countries may have been involved in them. I mean, think of the Iraq War, the second Iraq War in 2003. So this becomes really complicated.
It does. And of course, the elephant in the room is those who are currently indicted for international crimes. The effect of the Pinochet judgment was to determine for the first time that a former head of state could not count on immunity before national courts. And so what that effectively now means is that both before national and international courts, if you cross a line into international criminality and you then leave office, you are at risk of being arrested, of getting the tap on the shoulder somewhere around the world. In the midst of all of this has been established the International Criminal Court in The Hague, which has about 125 members, and that has a very clear rule in its statute that no one who is indicted by the International Criminal Court may claim immunity. Not a former head of state and not even a serving head of state. So this adopts the Nuremberg kind of approach. And what's happened in recent times, of course, is that a number of serving and former heads of state have been indicted by the International Criminal Court. One, very recently, has not only been indicted, but has been arrested and transferred. Former President Duterte of the Philippines, who's now in a Dutch jail awaiting proceedings before the International Criminal Court. But there are two cases that are particularly in the news right now. One is the indictment of Mr. Putin, which occurred in 2023 for the war crime against humanity of deportation of children from occupied Ukraine to Russia. And the second is the indictment of 3 Hamas leaders with 2 Israeli leaders, including serving Prime Minister Benjamin Netanyahu, for war crimes against humanity in relation, respectively, to crimes committed on the 7th of October and crimes committed on the territory of Gaza after the 7th of October. Now, in relation to those 2 individuals, there is an issue about immunity. The judges of the International Criminal Court have determined that they are not entitled to claim immunity, that the crimes were committed on territories of states parties, and therefore they have lost their right to claim immunity under international law. Both Russia and Israel say that is wrong, and they're supported by a significant number of countries, not just the United States, which is not a party to the Rome Statute, but in political terms by countries like Germany, France, the United Kingdom. And the argument is not without merit. Russia and Israel are not parties to the statute of the International Criminal Court. And so the argument is made, how can a head of state, former or serving, of a country that has not ratified the statute of the International Criminal Court lose the immunity they would otherwise have under international law? Because it's a general principle of international law that treaties only bind states that are parties to them. And so there is a colorable argument under international law that they continue to have immunity as serving heads of state, but once they cease to be serving heads of state, then they would lose their immunity. And so there's a lot of debate around those issues. But the broader theme that you're raising, and just to contextualize this, is after the International Criminal Court was created in 1998, it came into force in 2002, and basically for the first 20 years, everyone who was indicted was black and African. Let's just call a spade a spade. And blacks and Africans don't have a monopoly on international criminality. There was no indictments in relation to crimes committed by Americans on the territory of Afghanistan, Bagram, and so on and so forth. Afghanistan was a party to the ICC statute at the time of those crimes. No indictments in relation to British allegations of torture in relation to the Iraq War, where there was plainly jurisdiction. And it was pretty clear what was going on. This was big politics, and we, don't go against those countries. That's what was happening. So along comes the Russian occupation of the renewed war of Ukraine, and that presents a terrific opportunity to indict a white person. I mean, let's be frank, that is, in part, what is going on. But actually, the story is more complicated. I think the manner in which President Putin was indicted was a mistake. He should not have been publicly indicted. If he was going to be indicted at all, why not do it as other indictments have been done, secret indictments? And the reason that it was a public indictment is the prosecutor wanted the glare of publicity. He wanted to be able to say publicly, we're acting. Why? Because there was an initiative underway by that point to create a new special tribunal for the crime of aggression in relation to Ukraine. And the prosecutor was totally against that. The rationale for the creation of a new special tribunal, which has its origins in an article I wrote in the Financial Times on the 26th of February 2022 because I was asked by the Financial Times to write 700 words on Ukraine and international law. And the only reason they got in touch with me was because of East-West Street. Here's someone who knows about Ukraine, here's someone who knows about international law. The curious way in which a work of literary nonfiction then gives rise to a political development. And the prosecutor at the ICC was totally opposed to the creation of a special tribunal on the crime of aggression. You should know the ICC doesn't have jurisdiction over the crime of aggression, and that's why I proposed of aggression in Ukraine for technical reasons. That's why I proposed the creation of a new special tribunal, and the prosecutor didn't like that, wants to keep everything within the ICC, and therefore wanted to demonstrate, I believe, that he could exercise jurisdiction over the main man, Vladimir Putin, and that was why I think it was done in that way. Then along comes October the 7th and the subsequent horrors in Gaza, and the prosecutor's under immense pressure. He's got to be seen to be doing something, and he's got to be seen to doing something in relation to what happened on the territory of Israel, and he's got to be seen to be doing something in relation to what Israel's doing on the territory of Palestine. Palestine, incidentally, is a party to the statute of the International Criminal Court. So having publicly indicted Vladimir Putin, he has to publicly indict some people on the Israeli side and some people on the Hamas side. And so they've got themselves, I think, into this real difficulty. And the consequence, as you've seen, has been huge. The Trump administration has placed individual sanctions on individual judges, prosecutors, and others. And if news reports are to be believed, is about to sanction the entire International Criminal Court, which would have enormous consequences in terms of bank accounts and all sorts of other things in terms of using, Microsoft to run your computers and so on and so forth. So the issue of where we're at right now, it's a sort of inflection point on international criminal justice, and things could have been handled a bit differently. To be clear, I'm not saying for obvious reasons, I'm just made to be clear, that I'm against accountability and I'm in favour of impunity. I'm a realist, and the realpolitik of the situation is that it's a fragile system, and if it's going to be protected, safeguarded and grown, it's got to be used in a careful and in a wise way, and that's what gives rise to the charge of double standard.
Obama, in his incorrigible optimism, liked to quote Martin Luther King, "The arch of history is long, but it bends towards justice." At the moment, it doesn't really look like that. At the moment, the arch of history seems to be doing its own thing. We had a growing international rules-based order that has now been fragmented, softened, or simply disregarded. Where's this development going?
There's one book that I've been reading recently and giving out to people, which I think captures what's really happening right now. And it's by an Italian writer called Giuliano da Empoli, The Time of the Predators. If you want to read one book to understand what is happening right now, read that book. It's very short. You'll be pleased to know. But his thesis, which was summarized in a wonderful piece in the Financial Times, for those of you who are subscribers, about 3 weeks ago, is that the populists and the techno-moguls have come together to basically destroy the entire existing order, no less than that. And that begins with the legal order. And it begins by targeting the lawyers, the judges, the legal institutions. And he makes an absolutely compelling argument. And as you begin to see what is going on, the destruction of the WTO system, for example, followed by the attacks on the International Criminal Court, followed by the use of tariffs to basically drive a coach and horses through 80 years of rules on most favored nation and so on and so forth, you begin to see that there is method to the madness. And in reading Empoli, I came to understand in a better way the way in which we join all the dots and recognize the challenge to the order that was put in place in 1945 is absolutely existential. And I've just tried to address this in a piece I did for the Atlantic magazine that came out a couple of weeks ago on the subject of impunity, which is a sort of bedfellow to immunity, which is a sort of bedfellow to impunity. And I compared the 1999 judgment of the House of Lords determining that Augusto Pinochet did not have immunity for international crimes with the judgment of the United States Supreme Court of July 2024, which rules, in apparent contradiction to the Pinochet precedent, that a former American president has absolute immunity in relation to any official conduct that he does in exercise of his core constitutional powers, which includes matters of foreign policy, intelligence gathering, national security, and so on and so forth. Now, the Supreme Court does not address international crimes in its judgment, but it's very difficult to read that judgment and not leave with the very clear conclusion that if this majority of 6 were to be asked the question, does a former American president have immunity if he commits torture or disappears people or genocide? It's very hard to see how, on the basis of the judgment they've given, which is a very unfortunate judgment, not to conclude that he would have immunity even for those international crimes. And then I compared that ruling, which was written by Chief Justice John Roberts, with the letter that Justice Robert Jackson wrote to Harry Truman in June 1945 when he explained his thinking behind the drafting of the Nuremberg Statute. And he writes to the president and says, there will be no immunity at Nuremberg, not for anyone, even in relation to official conduct, because immunity is an obsolete relic. It is not who we are, and it is not what we do in our own system, even in the United States, a sort of implicit acknowledgement that the Constitution does not provide immunity for a former head of state. So that signals that the Trump administration appears to be supported also by the judges of the main and most senior court in the United States. And that, I think, indicates the sort of paradigm shift that may be about to occur. But it's a long game. And I draw my sustenance from a conversation that I had back in the mid-1980s when I was getting going as a research fellow at Cambridge University working with Eli Lauterpacht on international law. And I had a colleague who's still at Cambridge, wonderful person called John Baker, Sir John Baker, professor of English legal history, I was at St. Catherine's, he was at St. Catherine's, he would say, come and have lunch with me, tell me what you're working on. He'd ask me what I was working on. I'd tell him what I was working on. And he would listen as I described some tiny thing that I was working on. And he would say, yes, you had a little beard, and he'd stroke his beard. Yes. We had a similar problem in 1472 in English law. Then it took 275 years to sort it out. And I think that's the way to understand. You know, the world changed in 45. It was an incredibly revolutionary moment. And there are going to be ups and downs, one step forward, one step sideways, one step backwards, another step forward. And we're in that step backwards moment. But over the long run, even though I suspect the next 10 years are going to be terrible, it'll pick up again. And what history shows us is that if you go through the evolution of the international legal order, there's a period of construction followed inevitably by a period of destruction. And then they think, we've got to rebuild again. And when they rebuild, they always rebuild on the basis of what came before. And that's what will happen.
Philippe, I want to consult a really good legal mind and help us to pass something here. You have spoken about genocide, and of course, and people in this room are waiting for this question. We've been talking about genocide a lot recently. We've also talking about genocide a lot with relation to Israel. And is this a genocide? Is this merely a crime against humanity to expose people to hunger? How can there be a legal handle on that? I wonder whether it's such an important question, whether or not we can call this a genocide and whether or not it fits all the criteria for that. But as a lawyer, tell us what the definition actually is. Is this just killing a whole lot of people? Is this, and tell us especially what this has to do with Myanmar and the trial against Myanmar in the International Court of Justice.
So in a sense, this is where my different caps connect. I'm counsel for the Gambia in a case which is currently before the International Court of Justice against Myanmar, in which the Gambia alleges that Myanmar is responsible for perpetrating a genocide against the Rohingya Muslim community in Myanmar. And because I'm counseling a serving case, I'm really careful about what I say, because judges do not like it when people who are counsel go around mouthing off their views on X, Y, or Z. And the case brought by South Africa against Israel follows, and there's no question but that what the court decides in Gambia versus Myanmar will have huge implications for what follows in the South Africa-Israel case, assuming it proceeds and South Africa doesn't feel so clobbered by pressure from the United States to withdraw its case, which I'm sure the United States would be very happy with. So I've generally avoided doing interviews. I haven't done any except one. I've only done one interview on this issue, and that is in August of this year with Ezra Klein for the New York Times. And the reason that I did that as a listener of his podcasts is that it's very long-form interviews. He doesn't ambush people. He allows all the nuances and all the complexities to be drawn out. And he was incredibly well prepared, and I was very comfortable with the conversation and comfortable with the way it was then posted. And I know a lot of people have listened to it because a lot of people wrote to me about it. And I explained in what was a very well-structured interview by him, I thought, how this concept originated in 1944 by Raphael Lemkin, who set a very low bar. For Lemkin, one village, 9 people, 3 groups, A, B, and C, 3 people in each group. The folks from group B and C go and kill the people from group A. That's a genocide. It's not a numbers game for Lemkin. It's about targeting people because of who they happen to be in terms of their ethnicity, their religion, their race, or so on and so forth. He gets it into the Nuremberg proceedings, not as part of the statute, but as the indictment of Hans Frank and others, and is devastated when the Nuremberg judgment, and people forget this, doesn't make even one reference to the word genocide. It's not in the judgment. It's in the transcripts of the pleadings, and it's in the arguments, but the court doesn't refer to the word. So he devotes the next 3 years, 2 years, 46 to 48, to persuading states to ratify, sign, negotiate a treaty on genocide. And that's adopted in 1948. And in 1948, the Convention on the Prevention and Punishment of Genocide is adopted, but it sets a higher bar. And in particular, it includes a bar which says that the intention, the definition of genocide is the intention to destroy a group in whole or in part. And the key word is intention. What's intention? You don't, on crimes against humanity and war crime, have to prove a special intention. It's the mere fact of killing large numbers of people or mistreating them in particular ways. But genocide has this special intention, dolus specialis. And so that was the way that states reacted to stop the floodgates opening of lots and lots of cases. That was 48. Then really nothing happens for nearly 50 years until the horrors in Yugoslavia and Rwanda, and the Security Council creates 2 new international tribunals and gives them jurisdiction over genocide, war crimes, crimes against humanity. Incidentally, for me as an international lawyer, there's no hierarchy. Kill 10,000 people, I don't care whether it's a war crime, crime against humanity, or genocide, they're all equally terrible. But in the court of public opinion, genocide has somehow emerged as the crime of crimes, and there are lots of complicated reasons for that, I think. So finally, the International Tribunal for Yugoslavia and for Rwanda are faced with the interpretation of these texts for the first time, along with the International Court of Justice, and they sort of raise the bar even further by basically determining, this is the ICJ 2015, Croatia versus Serbia case that I argued for Croatia, that to prove that special intent in the absence of documents, and there never are documents, it's inferred from a pattern of behavior, and the pattern of conduct has to be such that the only reasonable inference, the inference must be that the only reasonable conclusion is that the intention is to destroy a group in whole or in part. And that creates a problem. If you've got multiple intentions, and there will be psychologists and psychoanalysts in the room who will tell you no human being when they act has one exclusive intention. There are multiple intentions and motives for doing things. And in the Myanmar case, Myanmar says, well, no, we don't intend to destroy this group in whole or in part. That's not the only reasonable inference. We're acting in self-defense. These people pose a terrorist threat to us. We have to respond to terrorist attacks. We have to act in self-defense, and so on and so forth. And so the court now is going to have to decide in that case whether that is, in fact, the reality. And what the court decides on the definition of intention and the proving of intention will have implications for what happens in the case that follows, South Africa versus Israel. So there's, in simple terms, a gap between what intelligent, ordinary folk think of as genocide, namely doing nasty things to large numbers of people, and this legal definition, which has sort of departed significantly from Lemkin's original intentions. And with that gap between the two definitions is where so much mischief is created. And the other thing to remember, and this is very unfortunate, is the International Court of Justice only has jurisdiction over the crime of genocide. For historical reasons, there's no treaty that gives the ICJ jurisdiction over war crimes and crimes against humanity. So if South Africa wants to go to the ICJ to challenge what Israel's doing in Gaza, the only way you can do it is to argue that it's a genocide. By contrast, the ICC has jurisdiction over war crimes, crimes against humanity, and genocide, and the ICC has not, thus far at least, indicted anyone on the Israeli side or on the Hamas side for genocide. The indictments are for war crimes and crimes against humanity on both sides. So you get a sense of the complexities of this situation. It's really complex.
What is also really complex is that time is running away, and we wanted to invite you as well to ask a few questions. And so, well, let me do just that. Please join this conversation. I think there is a microphone coming. There's a hand already held up. And there's also someone over there. Could I ask you, first of all, to ask genuine questions?
Of course.
Secondly, also to keep them relatively short so that other people also have a chance to ask.
I will do so. My name is Daniel Seller. First of all, thank you so much for your presentation. I have your book East-West on my bedside already for quite some time.
Because you haven't read it.
I'm halfway through, but I have listened to Ezra's Klein interview of yourself. A very straightforward question, which is probably not that easy to answer. I think you mentioned that you see yourself as a realist. Is in the case of Israel, Gaza, bringing the case of genocide, is it actually helpful for bringing justice to either side, to the suffering on the Israeli side and to the Gaza side? Because automatically it goes into the realm of delegitimization, a lot of politics. And I would be really interested to hear your opinion. And secondly, are you Lemke or Lobrecht in the end?
So, shall I answer this one now, or do you want to wait for the other one?
No.
Yeah. So, you've only got halfway through East-West Street, so you haven't got to the bits where it's very complex, because I admire and love Lemkin so much, but I really have a problem with the reification of the group in the legal order, but recognize as a realist that it's here to stay and we're just going to have to live with it. So I'm going to answer this question by reference to my own experience of doing cases on genocide. And what you observe, for example, in the case of Croatia and Serbia, is that this need to prove a special intention, coupled with the focus on the group, has a very unfortunate psychological consequence. It tends to reinforce the hatred of the perpetrator group and to reinforce the sense of identity of the victim group. Actually, as you will see in East-West Street, if you haven't got there already, there is a letter that Lemkin received in 1945, just a few months after he published his book Axis Rule, from a friend, private letter, it was never published, castigating him for his invention of a term which essentially, the letter writer says to his friend, adopts the same position as Adolf Hitler. You make the law premised on a biological conception. And this is very problematic. And I have to say, I've seen for myself, when you're advising a country and talking to the president or the foreign minister and explaining the complexities of proving genocide, it induces a sense of rage and anger, which doesn't happen with crimes against humanity and war crimes in the same way, because it's more straightforward. And so I've long argued that if we're going to have a concept of genocide, it would be better to go back to Lemkin's conception, lower the bar, make it more regular, more of an everyday thing, but instead putting it on some sort of a pedestal. So as currently conceived, my position is that genocide as a concept may well be part of the problem, and that because of its psychological consequences, there is a possibility that a term invented to do good may actually do more harm by turning one group against another. And there's another way of looking at this. Srebrenica was determined to be a genocide by the ICTY, the Yugoslav Tribunal, and the International Court of Justice. Vukovar, on the other hand, was ruled to be only a crime against humanity and war crime. And I can tell you, in Croatia, there is incandescence still today, more than a decade later. I mean, Misha knows this better than I do, that it's so unfair that they got a genocide and we only got a crime against humanity. And even within Bosnia, there is feelings of grievance for those who were on the receiving end of horror, which was only characterized as war crime and crime against humanity. Why is it only the people at Srebrenica who got a genocide? And all of this has caused me to reflect on the social utility of this hierarchy that has been created, not by any intention. Lauterpacht and Lemkin never had a hierarchy amongst these crimes. They had a real debate about whether you focus on the individual and the group, and reasonable people can disagree. And once you get to the end of East-West Street, if you ever do, you will see that I've got an internal struggle about it. I'm sort of intellectually with Lauterpacht. Focus on the individual, and then you avoid a lot of these difficulties. But when you get to the last page of East-West Street, and this is a single page on which I've had more correspondence than anything I've ever written, hundreds of letters and emails. What do I mean precisely in the last page? The last page, I'm in Zhulkiev, and I'm taken by a local municipal worker, a wonderful lady, to a secret mass grave in the town. I mean, really shocking, unmarked grave, in which there are 3,500 people still today, my grandfather's family and Lauterpacht's family. And I describe in the book that being in that place at that moment, I understand what it was that Lemkin was trying to do. I was acknowledging that I, like probably everyone, has a sense of tribal connection and identity, and that it's impossible to escape that sense. And that's what Lemkin was articulating. And so I can't give you a simple answer of whether I'm with Lauterpacht. I mean, what I can tell you, it comes back to a point I meant to make it earlier, in terms of how we maintain our sense. I mean, this is important when I'm speaking to my students in a very difficult time right now, where there's a sort of dismantling going on. How do you keep going? How do you think, well, this is a useful thing to do? I think of Lauterpacht and Lemkin. I think of them in 1942 and 1943 and 1944, when times were much worse than they are now, much, much worse. What did they do? They could have crawled into a corner and wept. They didn't. They thought, no, we're going to put our energies into ideas, and we're going to write, and we're going to do things. And they then end up being prosecutors at Nuremberg. And that image of those two characters is what, keeps us going. That actually, times are bad and it's difficult, but no, you don't give up. You stick to your principles, and ideas and words and books and articles actually can end up having a very significant consequence. So it's a very big question you've asked, and I am not able to give you a simple answer. And I can't say, yes, one this way or that way. I oscillate very frequently.
Can we have another question, please? I think there was a question from over here. No? Yes, the lady there.
I think it's also fine to say I don't know, or I oscillate, and it's fine to be contradictory and to recognize, we should do that more in life, that actually these things are complicated. And
Thank you. Ina Bedoskin, current fellow at IWM. First of all, thanks to all the organizers. It's an incredible opportunity. And thank you for all the work you're doing. I'm trying to read everything you write, but it's really hard to keep up. And I understand you were the first voice behind the idea of the special tribunal for the Russian crime of aggression. So thanks for that also. I heard what you said about history, and I agree with that. But if we take the victim-centered approach to justice, then the element of urgency is on the table. And there is a book by Alex Whitening called Justice Delayed is Justice Delivered. What do you think about that concept? And hence my question, how would you define justice in our age of impunity?
We live in an age of impunity, and my realist side comes to the fore. A lot of really horrible things are going to happen to a lot of people for which there's going to be no accountability. It is as simple as that. I don't accept it in the sense of willing it, but we have an imperfect system at the national level in our internal law. We know that also. It's not as though we can say our national systems are perfect and they deliver justice. We know that they don't. There are many things that are prescribed. There are many things that are unjust. There are many things that are unlawful that go on, and they're not repaired by a domestic legal order. And our international legal order is even more embryonic. I mean, we are sort of in the medieval ages, and that is not sustenance for people who are on the ground right now, on the receiving end of horror. But what can you actually say to such people? There's nothing I can say or anyone else can say or do to say, I can use the law to stop this or to ensure that those who violate your rights will be subject to a system of accountability. It's just not going to happen. So what do I do in those circumstances? I think through conversations that I've had with people. In November 2019, I did a seminar at George Washington University in America, in Washington, D.C. I was on a panel with a wonderful person called Thomas Bergendahl, who used to be the American judge at the International Court of Justice. And he's no longer with us. He wrote an extraordinary book, which I urge you to read, called A Lucky Child. He is a man who went on to do extraordinary things for the rule of law. But as a 10-year-old, he was in a place called Auschwitz under the care of a certain Dr. Joseph Mengele. And he survived and went on to have an extraordinary life. And when I was on that panel with him, I was telling him that I was about to go and do the provisional measures phase of the case brought by the Gambia against Myanmar. And he wanted to know what we were going to argue and so on and so forth. And he said, after I'd explained what our arguments were and why Gambia of all countries was going to do it, he said, Philippe, it is sort of extraordinary. I mean, we can't say there hasn't been any progress. I said, what do you mean? He said, can you imagine in 1944, I'm at Auschwitz, and a faraway country goes to an international court and waves a piece of paper called the Convention on the Prevention and Punishment of Genocide and says, you can't treat these children in this way. It's illegal. It's unlawful. Now, he said it probably wouldn't have stopped the horrors, but it would have signaled to us that we were not alone and that there were people out there who cared about us. And that would have been incredibly important to know. A month later, I'm in The Hague. We argue the case on provisional measures. And the court then orders unanimously, which is very rare, provisional measures against Myanmar in relation to certain acts against the Rohingya community. And that evening, those of us who are counsel for the Gambia are sent some photographs from Cox's Bazar, which is where there are hundreds of thousands of refugees, Rohingya refugees. And it was incredibly moving. Hundreds of refugees, Rohingya, in Cox's Bazar, holding up a placard above their heads, which simply said, "Thank you, Gambia." And those are the kinds of moments that don't stop the horror, but for people who are on the receiving end to know that there is a potential path to justice, to know that they are not alone, to know that they are not forgotten, is a very big difference from the situation that pertained in the 1930s and the 1940s. For the folks who were here on the streets, you know, brushing the sidewalks with their toothbrushes, where there was nothing, not even that. You know, as the great writer Madeleine Tien says, do not say we have nothing. It's imperfect. It doesn't go far enough, plainly. But it's not nothing. And I think we just have to keep going and keep building. But I completely understand the force of what you're saying. I absolutely feel that.
Philippe Sands has another appointment to go to, but I do want to give as many part of you the opportunity to say something. So can we collect 3 brief questions, please, and we give Mr. Sands the opportunity to answer on what he likes. The gentleman here, there's a young man in the back, and there's a gentleman over there. Please.
Is there anything that international law can do to help people in North Korea?
North Korea is the first question. The second gentleman was where? There, yes.
Yeah. Is there a way to undo the mistake of making the crime, to making the decision to make Putin accountable for his crimes, to undo it and then hold him accountable for it in Hungary if the meeting with Trump works?
There is a question of Mr. Putin, and if the mic can quickly travel to the other gentleman there, then so we have North Korea, and we have the question whether we could not have indicted Mr. Putin in a brighter way. But please.
Hello, I'm not quite sure if I understood you correctly, but why did you say that you thought that it was a mistake that the indictment of both Putin and Netanyahu should not have been made in public or not been publicized? That's a concept. How could that have been done, like under the cover, or what would have been the right way?
Indictment Mark II.
So North Korea, I mean, what can we say? It's gone on for decades and it's horrible. And there have been investigations and there have been Human Rights Committee reports and they've been to no avail whatsoever. There is no escaping the conclusion that in relation to North Korea, the edifice that was created in 1945 has failed. And we just have to recognize that and call a spade a spade. I think it may be that as North Korea now emerges from its isolation, albeit in tandem with Russia or in other contexts, it will be exposed to greater scrutiny and possibly to accountability. But for the time being, that has not happened. In relation to the the third question was the Putin question.
Question about why a secret indictment would have been better to a
And
public
the second
one.
question was, how could it be done differently?
Yes.
I mean, the two questions are related in a sense. I mean, it's very normal to have secret indictments. And that's what happened with Duterte. Nobody knew. There was no publicity given to it. And with some of the people in the former Yugoslavia and in Rwanda, there's no publicity given to it because you don't want to alert people necessarily that they are indicted. So you, by not alerting them, encourage them to continue to travel. And then when they travel, they find themselves exposed to difficulty. I suppose what has bothered me about the manner in which it was done, and I'm drawing a distinction between, on the one hand, the act of indictment, in which it seems to me that in both cases, I've not been involved and I don't know all of the details, but there's a colourable argument of involvement in crimes. It doesn't seem to me to be outrageous that either of those indictments were made. There's evidence to support both of them, and I think it was done pretty carefully, but by the ICC. But as you've seen, it's produced a tremendous backlash. And particularly, in both cases, in Russia, it has reinforced rather than undermined support for Putin because it becomes an attack on Russia. And the same thing has happened in relation to Israel and Mr. Netanyahu and Mr. Gallant and some third countries reacting as they've reacted. So is it for the prosecutor to ask themselves the question, I need to think through the unintended or inevitable consequences of my doing this in this or that way? If I was a prosecutor, I would ask myself those questions. What's the most efficient and effective way to proceed? And secret indictments have been, part of the story in domestic law, and, sealed indictments in the United States and in Britain. And I don't know how it works in Austria, but I assume you have a mechanism for ensuring that not everybody knows what has happened. Is a normal way of doing it. And it's about weighing up the equities and efficiencies. And I mean, it's not a critique of the prosecutor because I don't know all of the details, but just as an outsider, knowing something behind the picture, it just raises questions. Why couldn't it have been done in a different way? And I've tried to give you the answers to that. I mean, in relation to Mr. Putin, as you've heard, there are now conflicting responses. You've got the government of Mr. Orban saying he's very welcome to come to Hungary, and you've got the government of Poland saying, well, if he flies over Polish airspace, we may well face a Polish court order which requires us to bring the plane down. So different countries are reacting differently. The one thing I do know is that it really bothers Russia and apparently Mr. Putin that he's been indicted, because one of the conditions precedent for entering into peace negotiations between Russia and Ukraine is that all this sort of, as the Russians would put it, nonsense about international crimes is dropped. It really bothers them. And that's part of the tactical reason I wanted to work towards the creation of a special tribunal for the crime of aggression, which may never, in fact, come into operation, although I think it probably will, because it gives you bargaining leverage. I mean, the bigger issue here that's floating around is this huge and complex question of the relationship between peace and justice. What is the balance to be had? And there's no right answer to that. It's an issue that reasonable people in this room will be massively divided on. And at what point do you say the requirements for peace mean that you dispense with all of, or some of, or different forms of justice in order to bring an end to the killing and to the horror? And I think each of you will be thinking about that, and each of you will come to your own conclusions as to what's right and what's wrong in relation to these issues. And I don't think anyone has the right to say to someone else, you're wrong or you're an idiot for having that view. I think these are really complex issues that require you to look for the long term. And as we know, some countries, South Africa, Chile, less successfully, have had non-criminal penal techniques for dealing with justice over the longer term. I've just been for the first time to Rwanda a year ago in October last year, on the occasion of the 30th anniversary of the genocide in Rwanda. And it was really affecting to meet many, many Rwandans who would talk about the system in Rwanda of a process of local justice called the Gacaca courts, which, you know, is imperfect, as is every system, but nevertheless seems to have created within that country at least a modicum of stability and engagement. So that's the big issue I think we all need to be thinking about. In Russia, Ukraine, what would we actually do if we were at the negotiating table on both sides? And in relation to Gaza, Palestine, and Israel, what would we actually do in order to move things forward? And I think the moment you ask yourself that question, you realize actually it's sort of complex, and reasonable people can have different views about how you move things forward. I mean, after 1945, the decision was basically to put a handful of people on trial in this big thing called Nuremberg, and then, have some other trials, but actually that was where the center of gravity was. And that seems to have had a significant effect in the German context, and also, I suppose, possibly, although maybe not, in the Austrian context. There were 3 or 4 of the original 24 indictees were Austrian, but I don't think it was seen as a trial. It was described as a trial of major German war criminals. It wasn't described as a trial of major German and Austrian war criminals, which is sort of interesting to me. And that too had its own consequences. So these are really complex questions you're asking.
Philippe, thank you very much. We're all invited to keep thinking and come to our different conclusions and keep talking about them and respect those opinions, which is a refreshing call today. I can only say thank you to the Bruno Kreisky Forum, to the IWM. Thank you for the Museumsquartier for your wonderful hospitality, to the RD Foundation for making this possible, and of course to Philippe Sands and to you, a magnificently engaged and really concentrated audience. It was an absolute pleasure to talk with you and especially with Philippe. So Philippe, thank you very much.